Good morning. Welcome to another oral argument session with the 5th District Court of Appeal by Zoom. It is now 9 a.m. on Thursday, February 9, 2023. I am Judge Lambert. Up on the screen, we have one case this morning. It's case 22-164. Yoon Miao, M-I-A-O, I apologize if I'm mispronouncing, versus Jennifer Laird and Fernando Lopez. Joining me on the panel today are, as you can see them on the screen, are Judges Makar and Harris. This is a civil appeal. Each side will have 20 minutes. You can see, at least in my upper left-hand corner on my screen, is the clock that will be maintained by our marshal. It is preset for 5 minutes rebuttal time for the appellant. So if the appellant would like some different amount of time, just announce that and the marshal will adjust the setting on the clock accordingly. Remember, we are being watched theoretically, or we are available to be watched, I'll say it that way, on YouTube. So we are, so there may be people out there watching and listening, so keep that in mind as you make your arguments. If you have any type of electronic device or what have you, please put that in either the off position or mute so that it does not go off and bother either you or your opposing counsel or the judges during the course of the argument. So is it Mr. Thalwitzer?
Yes, Your Honor. Good morning.
Okay, sir, if you're ready to go, feel free to proceed.
Thank you. May it please the court, I represent the appellant landlord in this case, Wendy Miao. I'd like to reserve 8 minutes for rebuttal, please.
Okay.
We're asking the court to reverse the trial court's order of summary judgment in the appellee's favor and to remand for entry of summary judgment in our client's favor or for trial on the merits. We're entitled to the requested relief because, in essence, our notice was timely under Florida Statute 89.49.
Let me ask you, do you agree that if, in fact, the tenants vacated on March 30 and your letter was, your client's letter was set on April 30, that it would be untimely if those are the facts of the case?
Yes.
Okay. And did the written lease itself describe how it is that possession, and the lease itself says it terminates on March 30, 2023. Appears to be no dispute that that's when it's supposed to end. No intent on holding over that, or certainly it was not your client's intent that the tenants hold over. Is there something in the written lease itself that explains or directs how it is that possession is to be turned over by the tenants to the landlord? I couldn't find any.
I had the same question. I think the closest that the lease comes to providing an answer to that is in section 27 sub D, which is basically the last page of the lease. I'll read it. It says, it's very short. No agreement to accept surrender of the premises from tenant will be valid unless in writing and signed by landlord. There's nothing like that in the record. So to the extent that vacating is either equivalent to surrender, and to the extent that the appellees are arguing surrender, I think the lease undermines that argument because the clear terms of the lease require a signed writing, which doesn't exist.
Go ahead. Thank
you. A lot of this case, I think, turns on the definition of the term vacate or vacating from the statute, 83.49.
Is the statute define the word vacating?
Pardon?
Does the statute define the word vacating? I mean, it says upon the premises for termination of the lease, which is apparently what we're talking about this morning, then there's certain notice requirements that have to be met by the landlord if there's going to be a claim or non-claim on the security deposit. So,
well, the statute does not define it.
Well, let me jump ahead a little bit. I mean, the 900-pound elephant here is the videotape that you apparently like now. Assuming there was no videotape, or correct me if I'm wrong, the judge did not view a videotape, did he? Or she, excuse me?
I don't think we know one way or the other unequivocally. It's not stated in the record as far as I can tell. I don't have any evidence showing that the trial judge did, but I also don't have any evidence that she didn't.
Well, she didn't mention it in the final order that's before us.
That's certainly true.
Okay. And so if we take the video out of the equation for a second, then it seems that the only disputed issue that is being raised by your side as the counter evidence of the motion for summary judgment is the affidavit that was submitted, correct? By your client?
Yes,
I mean,
that's correct.
and that affidavit, I guess paragraph 9 is that affidavit is what would be in your view or your side's view, the raising of the disputed issue of material fact here to preclude the entry of a summary judgment. And your client says that they were in possession of the keys because the keys were not provided until April 2, when your client received an email from, ironically, that guy right there, I guess the counsel for the tenant, saying, here's the keys and the garage door. They're left home inside. They were left inside the home on that date, April 2, right?
Correct.
So, I mean, your client didn't actually get the keys and physically get the keys, according to the affidavit, on April 2. She's saying, I got a letter that says, oh, by the way, they're in the house, right?
That's correct. Yeah, I think it was, yeah, that's correct. I think it was an email, but yes.
Okay, and you believe that in and of itself raises enough to allow this case to go to a jury, and a reasonable jury could find in your favor as the standard that we now apply under summary judgment rule?
Yes, the trial courts, I think the key finding, which is problematic, is in section 4 of the final judgment. It says that I've read this 100 times and it's a tricky sentence, but it says that the defendant does not claim that the plaintiffs did not leave the keys in the dwelling unit as of March 30th, 2019. So it appears from this that the trial court was looking for an affirmative statement from the plaintiffs that the keys were not there. First of all, I don't think that's necessarily dispositive. Secondly, I think it's a bit of a semantic argument there, or finding. We put in our affidavit exactly what we knew. Well, the video, in fact, shows what really happened, and obviously that was the tenant's evidence. They can hardly dispute what it shows. But that finding, that we didn't claim that they didn't leave the keys, is in itself, I think, unsupported by the evidence. It's not even disputed that they left the keys on March 31st, 2019.
Well, let me ask this. Then. Let me ask this hypothetical. And again, I'm using the word hypothetical. This is the pet peeve I had as a trial judge and appellate judge. So when I say it's a hypothetical, your first response when I'm done should not be that's not the facts of the case. Because I'm trying to understand the legal principle here that you want to rely on. So let's say on the 30th of March, the tenants are moving out, taking their stuff out of there, and they email a letter to your client saying, it's after 5, we've got all of our stuff out of the unit, but we don't want to come after hours. So tomorrow morning on March 31, we're going to drop off the keys and the garage door openers at your office, Miss Landlord. And they do. And there's no response from your client, to that email. And I'm not saying she should or shouldn't, but there's no response to that. The keys are dropped off on the 31st. Let's assume that's in an affidavit by the Miss Laird and Mr. Lopez. Your client's then silent until April 30. And sends the demand letter or the claim on the security deposit letter that is that issue here that's undisputed that was sent. Under those facts, would it be your position that summary judgment would be inappropriate because you would have sent your letter on the 30th day, March 31 to April 30? Would that be your position?
if I can ask the one question, I want to confirm the keys in this hypothetical were dropped off at the landlord's office, not at the subject premises.
Or that was my hypothetical. I don't know that it's dispositive. Let's say let's follow through on that. If I'm seeing where you're going, they said we'll just leave it in the house there, you know, the first thing in the morning or what have you, and your client goes and gets it on the 31st. Okay, so now your letter is the 30th day. Under either of my scenarios, would you believe that this is a question that a reasonable jury could find in favor of your client, suggest that the letter was timely, if that was a question that they were asked to resolve?
A lot closer, certainly.
Is it?
So I think the question comes down to whether the keys, and only the keys, can essentially hold up possession or vacating.
That seems.
I'm not sure.
Well, that seems to be.
I'm not sure.
It seems to be your position here that if we look at the video, let's assume for the sake of your argument today, we're looking at the video, this happened on the 31st, or if we look at what the judge was deciding at the time she was handling the summary judgment motions and the motion for reconsideration, that there's the counter affidavit. There's nothing, there's no evidence from your side that says, you know what, I went over to the house on the 31st. And oh, by the way, all kinds of tenant furniture, TVs, et cetera, were in the house. So here's my affidavit. This is what I saw. She absolutely did not, or tenants absolutely did not move out. If that was your affidavit, then I think your case is better. I'll use that term. Do you follow me?
I do, and I agree with you.
And we don't have that here. So it then gets back to, okay, when was possession turned over? So that your letter is either timely or untimely? Was it turned over because the keys were not deposited using your affidavit date of April 2, or if we then factor in the video of March 31? The question here before there's other questions I have is, well, is that enough to say that I was still in possession, or they were still in possession?
Yes, if I follow your hypothetically, then
there doesn't seem to be anything from your side that says that, oh, by the way, there's all kinds of things in there. They were still living there. It's evident they were living there. They didn't vacate the unit, however one would consider it. Even if the lease ended, they still look like they're living there, because look at the neighbor filed an affidavit, my property manager, whoever. So that seems to be the question.
And you used the term living there, and that appears in the tenant's brief as well. I don't know that that's the test. The statute certainly doesn't discuss that or use that terminology at all. We're left with the plain meaning, the ordinary meaning of the term vacating, and I think both sides agree, or at least cited Black's dictionary, which provides, I think, a pretty good definition of the term. We've got it that, and I'll read it. Vacate, to move out, to make vacant or empty, to leave, especially to surrender possession by removal, to cease from occupancy. So if that is the definition, I know that that's potentially what the court may decide here, or at least what's at issue here, but that's not what happened on the 30th. They still had the ability and did in fact return on the 31st.
Okay,
they did not vacate because they came back.
They
had access and they were in the property doing things for their own benefit.
Just so you're aware, the yellow light that's flashing means you're in your rebuttal. If you want to keep going, that's fine. It doesn't matter, but I just let you know.
If the court has another question, I'm happy to answer it. Otherwise, I'll keep my rebuttal time.
Okay. I don't.
Okay, right. Then I'll rest for now.
Okay, very well. Okay, all right. Mr. Stewart, go ahead, sir.
Good morning, Your Honor. This is a really simple case, and it got muddled by arguably some good lawyering. But the fact of the matter is that you know who unequivocally had access to this video was opposing counsel at the trial court level. This video was provided to them back in June of 2021. On June 8th, opposing counsel requested or filed a motion to continue shortly before the hearing that had been properly noticed and scheduled for the 10th. So we heard the motion to continue on the 10th, the day that the original motion for summary judgment was scheduled. And as the basis for the continuance, it was that they had just been provided the video and wanted time to review it. So the continuance was granted. After reviewing the video evidence, we reset the hearing. The motion for summary judgment was reset for, we filed the notice of hearing on July 14th, 2021, and the hearing was had on August 11th, 2021. The motion for summary judgment was denied. The order was published August 17th, 2021. On September 10th, we filed our motion to reconsider. On October 1st, we filed a second and separate motion for summary judgment on totally separate issues. The hearing for those was noticed on October 21st, 2021. We had to fight to get the notice of hearing included in the record because ordinarily these notices are not included in the appellate record, but we won that argument. And so you will find the notice of hearing.
Counsel, just for a second, who did you have to fight with? I mean, I
don't know that it was a fight. I think it was a discussion probably had with the records custodians. And my paralegal described it to me as a fight, so
well,
I was
I'm
paraphrasing.
Just curious, if somebody in our office here is fighting with you as the clerk here saying we're not going to accept it, I would.
It was a colloquialism, Judge.
I would know that as the chief judge. So, go ahead.
I will, as a collateral issue, I'll find out more and send you an email. But I doubt it was an actual fight. But my understanding is that notices of hearing are typically not included, but we felt it was important to include it. So if you look R at 271, you'll see that the notice of hearing for both the motion for reconsideration and the newly filed motion for final summary judgment was noticed for December 14th. At all times germane to the lower court, opposing counsel was in possession of that video. They filed an affidavit in opposition, which we discussed during opposing counsel's time. You questioned them, and arguably, that's what things really come down to.
Counsel,
there was an affidavit.
Counsel, if I could interrupt, I'm a little befuddled about this video because what are we supposed to do? Look at the video and see some keys sitting on the counter? Is that what this is all about?
So before I will address your question.
I hope so, yes.
I will address the question. As it relates to the video, we do not believe it's part of the record. That was the only basis for which we fought the video.
Just hold on, Counsel. We
Yes.
have limited time. We have questions. I want questions answered. I'm befuddled, and actually it's a friendly question, which I think, which is, what are we going to do with this video? We're going to look at it. We're going to see some keys sitting on the counter on a couple of days after the folks had moved out. I don't understand why there's a fight over that. Let's say the keys were left the day after they, quote, vacated or left and so forth. What does that matter? I mean, the lease had expired on the 30th. Your client had asked that there be a walkthrough where they would give the landlord the keys. The landlord said, no, I'm not going to do it. So your client left the keys there the next day. That's the fact pattern, right? I'm sorry.
As far as the record is concerned, that is the fact pattern. And to directly answer your question, the video was not taken to show the keys were in the premises. It was actually taken to show the condition of the premises for in the interest of recovering the security deposit.
Well, okay, that's fine. Whatever the purpose was, it doesn't matter, at least as far as I'm concerned. But it just seems to me that what the trial judge had before her was enough to say, well, these folks moved out. they wanted to pass the key. The landlord didn't want to meet with them, so they put the key there the next day and did this video. That's the fact.
I agree, Your Honor.
Okay.
Go ahead.
Oh, okay. So other than the video, the things that were considered at the original motion for summary judgment and then the subsequent motion for reconsideration were obviously our motion for summary judgment, my client's affidavit, which is R91, opposing counsel's affidavit in opposition, which appears in the record R at 99. And that's it. That's all we had to consider for summary judgment. And I believe the chief judge hit the nail on the head. Our affidavit contains a sworn statement that said we were out the 30th. Opposing counsel's client's affidavit, the appellant's affidavit, contains a statement that said, well, I didn't go back. Plaintiffs were still in possession of the property as of April 2nd, 2019. Since the keys to the property were not provided to me until that point, I received an email from their counsel stating that, Blake Stewart Esquire, on April 2nd, 2019, stating that the keys and garage door openers were left inside the home as of that date. That's not the issue.
Pardon me for interrupting. Has the landlord claimed that this is a holdover? In other words, if a tenant holds over, and this lease expired on the 30th, they would be essentially holding over under the landlord's theory, correct?
That would be correct, but that was not argued at any point in time in the lower court.
Okay. Is there anything in the record that shows what the alleged damages are? Like what in the building and the home was damaged? Is there anything in the record on that? If there's not, then please don't say it's outside the record and I'll let you know. But is there anything in the record on what the actual alleged damages are?
I cannot remember if it was properly filed. What I can tell you was that I believe there was an initial response to our lawsuit that was pro se. The appellant was originally pro se, and she filed a response that I believe contained some allegations of damage, arguably that were not supported by the very video we're discussing today. So if we look at the affidavits, we're affirmatively stating and were completely moved out June 30th. Her argument that she can send the letter a day late is that she didn't know we were out and that she gets to toll the statute of limitations for her ability to send the letter based upon the fact that she was not informed we were out until April 2nd. And that's not the law. Most importantly, the reason I brought up the notice of hearing is because there's another issue, and that is that there is no possible outcome. If your honors are inclined to send this case back down on remand, there is no possibility that this case can result in a different outcome. It is impossible. The reason for that is because when we filed our second motion for summary judgment, it was not responded to within the time period prescribed by the new rules for summary judgment. So our second motion for summary judgment was argued, it was heard, and it went unopposed. So assuming arguendo that everything comes down to this video, and I have more to say on that, but I don't want to introduce it. Upon questioning, I'll answer questions, but as it relates to the video, if we're saying, okay, the video was taken the 30, go ahead.
I'm sorry, one more question. Why was the lease drawn through March 30th of 2019 rather than the last day of the month? I understand it's there. That's the date that's in the lease agreement. But I mean, it seems to me that what's really happening here is the lease ended on a day, the 30th, one day short of the end of the month. If I was the landlord, I would want my lease to go through the end of the month. So when I do send out the notices regarding the security deposits, that it's always going to be 30 days from the last day of the month. Any idea why this ended on the 30th rather than the 31st? Your
Honor, I have no idea, but it was drafted by the landlord. So to that extent, you know, any ambiguities or issues get, you know, we have to hold that against the landlord that provided the document.
All right, thank you.
So if you have any questions, I believe that, you know, our position was quite clear in the brief. Want to ask me about the video, I'm happy to answer questions about the video. But in closing, video or not, had the video, had opposing counsel made an argument in the lower trial court about the video, that would have been resolved. I can unequivocally tell you it would have been resolved without issue. It was not done. This issue with the video, and we didn't even realize it was an issue until after final summary judgment, after a new attorney was hired, and a second filing, you know, I believe it was a motion to reconsider, which is what triggered the entire appellate process. So new lawyer, new argument, great job, here we are, but this was all provided. Everybody had access to this video, and it was never raised effectively until post-judgment.
You done? I mean, you can continue if you want, but you don't have to.
I believe I believe I'm ready to rest.
Good enough. All right. Thank you, counsel. Counsel?
May I
go ahead.
proceed?
Yes, sir.
Thank you. So to answer the court's question about damage to the unit, I don't know how critical it necessarily is, but I did want to point to the record. It's at page 55 and 56. There may be other evidence, but it's our client's response to interrogatories in which damages are discussed and summarized. Going back to the concept of vacating, I think a lot of what the tenants are arguing is about their subjective intent. Intent's irrelevant here. The question is whether they actually vacated. They didn't. They came back. They entered the unit. They did so strictly for their own purposes. They took a video. They brought counsel. That's when they left the
Counsel,
keys there.
Counsel, aren't you overlooking that your client was asked to be there and refused to be there?
No, I don't think so. I'm aware of that, but no, I don't think that's material. Nothing stopped the tenants from doing whatever walkthrough they wanted to at any time. It wasn't dependent on my client.
But the walkthrough would not be when they're still there. The walkthrough would be after they vacated.
Which they could, they cleared out the unit ostensibly on the 30th. They could have done the walkthrough the same day. The reason they didn't, they said it got late.
Well,
Okay, well, they still could have done it. Instead, they maintained possession of the unit, came back the next day. That was their choice. No one stopped them. My client had nothing to do with that.
okay. What about my question regarding the date in the lease? Why is it March 30th, not March 31st?
I have no idea.
Okay.
It may be just a quirk or an error. It may have been intended to be the last day. I don't know, though.
That seems.
I agree. It would have been cleaner to be the last day, though.
Right.
Certainly.
Mr. Tholowitz, are you
But-
saying that the tenants physically moved everything out? You seem to agree with that on the 30th. They were out as of that day. But because they came back a day later, you're saying that their possession continued? What if they came back 10 days later to do this walkthrough? If they vacated on the 30th, they came back in without permission, that's a different issue. But does that mean during those 10 days, the interim 10 days, they kept possession of the property? You seem to agree
Assuming
that
nothing else changed? Yes. If they kept the keys, didn't tell us anything, and just came back 10 days later and did their walkthrough, letting themselves in and then left the keys, I don't think that would change. It might be an unusual situation, but the argument's the same. I don't think the passage of time changes anything. Assuming no other facts changed. Now, they probably would have, but that's the assumption.
But they weren't required by the lease or by the statute to physically give you the keys and the garage door opener, were they?
It doesn't mention it either way.
It's some indicia.
But I think that is part of vacating.
Okay.
Vacating is essentially relinquishing possession. Physically speaking, the access devices are how we obtain possession and maintain possession, how you get in and keep others out. So I think that is a critical component of it, though it's not the only fact.
Well, what if they just said, this is going south with our landlord, we're leaving, and we're just taking the keys and the garage door opener with us and throwing it in the Atlantic Ocean. But they physically have vacated on the 30th. Your client could have walked, let's say your client could have walked in on the 31st and says, oh goodness, nobody's here. Good deal. Lease is over. I'm now in possession, because probably a fair assumption your client probably has a separate set of keys to some house that they own, or she owns, excuse me.
I don't think that would change it.
Well, I mean, it seems to me is that your case rises and falls on the fact, unless tell me otherwise, that these people didn't turn over the keys within, they did not turn over the keys, and you sent the letter within 30 days of turning over the keys.
It's not just the keys, though. It's also the fact that they used the keys, they entered the unit, they took a video for their own purposes, and then they left the keys. So the keys are a piece of it, no doubt, but that's not all they did. So I think it's important to emphasize that they entered the unit. They had possession of the unit. They could have done more. They decided not to, but they still had the unit. We did not have the keys. We did not have possession.
What does the lease say about the walkthrough? I'm sorry, I don't have that right in front of me, that portion of the lease, but what does it say about the walkthrough, how it's supposed to be done?
I don't think it specifically addresses it, but as I said earlier, as far as surrendering the premises, that requires a writing signed by the landlord. So if they're surrendering, that's what's required. And that simply does not exist. I don't think there's anything about a walkthrough. I could be mistaken, but I didn't see anything.
Okay.
Going back to the video, I think it's critical also to note that the tenant referenced the video at least 4 times in the lower court record.
Well, counsel, let me ask you this. Under the new rule, if you want to rely on some evidence, isn't it to oppose a summary judgment, don't you have to bring that to the judge's attention with a reply, which wasn't done prior to the summary judgment being entered here? And absent a reply, the trial judge under 1.510 has certain discretion to be able to consider the fact as undisputed and grant summary judgment on the supporting materials, i.e. the affidavit filed by the tenants here. So, I mean, if you haven't complied with it, and I know you weren't counsel, but below.
I understand what you're saying.
Yeah, I mean, how is that? I get what you're saying in a visceral sense, but how is the judge err here if your side does not bring to the attention under the rule saying we are relying upon this piece of electronic information in the record ostensibly put by the tenants to defeat the tenant's motion for summary judgment? Can't the judge absolutely do that? And is that basically problematic for you?
I'm looking at the rule right now because I have to look at it every time, the new rule. But I see what your Honor is saying. I understand. For some reason, I'm remembering that the court does have discretion outside of that, but maybe that's just what frequently happens. I'm not.
Well, the judge has the discretion to give the non-moving party an opportunity to properly support, but also the next E2 says can consider the fact undisputed for purposes of the motion, grant summary judgment if the motion, i.e., the tenant's motion with the affidavit saying we vacated on the 30th, and including the facts considered undisputed. And clearly, if the judge accepts the tenant's affidavit here, then summary judgment's appropriate, and the video was not referenced by your side to be considered as opposing evidence under the rule.
Well, under sub C3, I think this is what I was thinking of. It's called materials not cited. It says the court need consider only the cited materials, but may consider other materials.
And may choose not to, right? Isn't that?
Absolutely.
Okay.
I agree.
All right, counsel. Our time is up. Thank you very much. We'll take this matter under advisement. Have a good day,
Thank
gentlemen.
you.
Mhm.
Thank you, Your Honors.